You know how it is with HOAs, right? Every community has its rules. Sometimes they're just background noise. But what happens when a rule, or maybe how it's enforced, pushes somebody just a little too far? Well, we're about to dive into a case where one single 7-minute neighborhood meeting totally blew up into a full-blown legal battle and put the very idea of a meeting on trial.
So, take a look at this. This isn't some friendly reminder about holiday decorations. No, what you're seeing here is the real deal. An official dispute petition filed with the state. This one piece of paper is what takes a neighborhood disagreement and turns it into an actual legal proceeding. It's one homeowner, all on his own, against his entire association. And the fight is over transparency, procedure, and really the fundamental right to be heard.
So how in the world did it get to this point? Well, you've got two completely different stories. On one side, you have a homeowner who is absolutely convinced the law was broken. And on the other, you have an HOA board that's insisting they followed the rules perfectly. It's a classic standoff, really. And it gives us this fascinating window into how local power works and what happens when two sides have a completely different idea of what the rules even mean.
All right, so let's meet the players in this showdown. First up, the person who filed the complaint, the petitioner, is homeowner R.L. Whitmer. And on the other side of the table, defending the HOA's actions, we have the Hilton Casitas Council of Homeowners, represented by its board president, Robert Westbrook.
And get this, this wasn't just about a principle. To even kick this whole thing off, the homeowner had to put down $500 for the petition fee. $500! That's a serious commitment, and it tells you right away just how strongly this guy believed that something had gone really wrong. I mean, that fee alone just immediately raises the stakes.
So what was the spark? What was the one thing that set this whole fire off? Well, it all goes back to this one special meeting on the evening of April 7th. Everything that went down in just a handful of minutes that night would become the bedrock for this entire legal challenge.
I mean, just look at how fast this all went down. The meeting kicks off at 4:02 p.m. 3 minutes later, the ballots are counted, and by 4:09 p.m., just 7 minutes from start to finish, the whole official thing is over. Done. But here's the kicker. The real controversy wasn't just about what happened during those 7 minutes. It was about what happened right after.
Okay, so the homeowner's complaint really boils down to three main points, three big allegations. Number one, the HOA didn't provide an agenda. Number two, he was denied his right to speak. And number three, after the official meeting ended, the board held a secret illegal meeting disguised as a casual town hall. So let's dig into each one.
All right, first up, the agenda. You might be thinking, an agenda? What's the big deal? Well, in the HOA world, it's actually a pretty huge deal. It's all about transparency. The homeowner's point was pretty simple. Without an agenda, how is anyone supposed to know what's going on? You're just walking in totally blind.
So here's the big question for this part of the dispute. Did the HOA actually have to provide a formal agenda? Legally, I mean. Was this just a simple mistake? Or was it, as the homeowner believed, a way to keep people in the dark?
So you have the homeowner, and he's arguing for the spirit of the law, right? The whole point is transparency for everyone. But the HOA's lawyer, well, they got very technical. They said, whoa, hold on. That law you're talking about, that's for board of directors meetings. This was a members meeting. Totally different, in their view. And besides, they argued that the ballot packet they mailed out, well, that was basically the agenda.
And this is the actual law the homeowner was pointing to. You can see his point, right? It seems pretty clear. Conducted openly. Agendas be provided. This is where the whole conflict really comes into focus. You've got the big, broad idea of transparency clashing right up against the nitty-gritty technical details of the law.
Okay, so that's the agenda. But the next point, this one feels a lot more personal. We're moving past paperwork and procedures and into something really basic, the right for any member of a community to just speak up and be heard.
And this is where things get really, really interesting. Because this entire part of the fight, it all hangs on how you interpret one single sentence. The question is, did the homeowner actually ask to speak, or was he just making an observation?
So the homeowner side is, look, when I said I was waiting for public comment, what else could that possibly mean? Obviously, I wanted to talk. But the HOA's lawyer, they're like, nope, he never said the magic words. He didn't say, I want to speak, or I have a question. And in their book, waiting for a chance to talk is not the same thing as actually asking for it.
And there it is. That's the sentence, right from the official hearing transcript. The whole argument hinges on those 6 words. I'm waiting for the public comment. So what do you think? Does that sound like someone asking to speak or just stating a fact?
And here's the counterpoint, straight from the HOA's lawyer. It's a masterclass in legal precision, right? They're basically saying that in a formal setting, you have to be totally explicit. Waiting is not requesting. It just goes to show you, in a legal fight, every single word counts.
All right, on to the final piece of the puzzle. This one is all about what happened after the meeting was officially adjourned. The board president invited everybody to stick around for an informal town hall chat. Sounds nice, right? Well, not to the homeowner. He saw it as something else entirely.
So, this brings up a really fascinating question. When does a simple chat between neighbors turn into an illegal meeting? This is what that third allegation is all about. That super blurry line between just talking as a community and conducting official business.
The homeowner's point was pretty simple. He said, look, you had a quorum of the board there, that's just a fancy word for a majority, and you were all talking about HOA stuff. That, by definition, is a meeting, and meetings need to be announced. But the HOA's response was, no, we were just neighbors hanging out. Board members are people too, They have a right to just be there as individuals.
And this is where the HOA's lawyer came up with this really interesting idea he called the two hats theory. Picture this. A board member can literally take off their official board member hat and put on their casual, I'm just a neighbor hat. And with that hat on, he argued they can chat about whatever they want without it automatically becoming an official rule-bound meeting.
So when you step back and look at it, this one little neighborhood dispute actually forces us to ask some really big questions about how our communities are run. It's about so much more than just one meeting. It's about the very definition of transparency, participation, and local governance.
So why should you care about this one case? Well, because pretty much every HOA in the country is trying to walk the same tightrope. It's this constant balancing act, isn't it? Between following the rules to the absolute letter versus understanding what the rules are actually for. Or the balance between making sure everyone gets a voice and, actually letting a meeting end on time. And maybe the trickiest one of all, how do you allow for casual neighborly chats without accidentally holding an illegal meeting?
And in the end, that's really what it all boils down to. It leaves us with this one final provocative question. In a world that's filled with rules and boards and statutes, where exactly is the line between a few neighbors just talking and an official meeting where business gets done? As this case shows, the answer is nowhere near as simple as you'd think.